juncture, Manoj. So we have chosen, Manoj, that
एक बार YouTube पे
model.
देखना आया लाइव क्या?
मैं नीचे बारबेक्यू घूम के भी आ रहा हूँ।
So let's go ahead. Lord, your lordship have my lord, the centralizing
नीचे
thing.
थर्ड फ्लोor पे था।
So I made myself here. I'm not putting it.
कितने मनोज सर ने खींचा आवाज
governance.
मनोज सर ने खींचा डांस करो
That Delhi is the union territory. Lord, NDMC 9 judgment and your lordship's constitution bench judgment. That it is union territory. Yes. And is a completely separate unit of governance, distinct and different from the union and the state. It is required to be pointed out that the provisions of services, this is very, very crucial. This is the heart of the matter. It is required to be pointed out that the provisions of services are made in chapter 14 of the Constitution having the title Services under the Union and the States. It does not categorically mention union territories. There is a deliberate silence, which will become clear, Manoj, further, that it's not just a coincidence that it is not included. There is a conscious omission. The Constitution, which is fully aware of three units of governance, that is union, the state and the union territory, categorically excludes the union territory from the said chapter under the heading services under the union and the states. In other words, there are only two categories of services contemplated under union services or posts in connection with affairs of the union. In connection with the affairs of the union is the phrase I have borrowed from Article 309 itself. And two, state services or posts in connection with affairs of any state. There is no contemplation of any separate and independent services for union territories, since any union territory, whether with or without legislature, is constitutionally an extension of the union, and not only statutes but the Constitution recognizes the above position as stated above. All India services officers selected by UPSC or a board controlled by the central government are deployed in connection with the affairs of the union territory, since such affairs are necessarily in connections with the affairs of the union. The inevitable conclusion in chapter 14 under the heading services under the union and the state is that it does not apply to union territory, which becomes clear from Article 308 contained in Part 14 itself. Not the first article, and this is again not clinching in my respectful submission. At this juncture, it is relevant to note, and you will note this, this is very, very, very relevant. At this juncture, it is relevant to note that Article 308 of the Constitution was in existence even prior to the insertion of the concept of union territory, which came to be amended by 7th Amendment. Union territory came in 7th Amendment, but 308 was there, by which the concept of union territory is also introduced in Part 8 of the Constitution, and the concept of an administrator to administer the affairs of union territory was also introduced by very same amendment under Article 239. Though Article 308 came to be amended simultaneously with introduction of union territory and the contemplation of an administrator to administer the same, the Parliament did not incorporate union territory within the meaning of the expression state. Lord, this is the amended provision. Lord, kindly see the title, Part 14, Services under the Union and the State, Chapter 1, Services, Interpretation. In this part, unless the context otherwise requires, the expression state does not include state of Jammu and Kashmir. This is the only amendment. Simultaneously, this is a part of 7th Amendment. The Parliament could have said state would include union territories, because elsewhere in other provisions, Parliament has said in the 7th Amendment itself that the word state here would include union territory. Parliament doesn't say, Manoj, in the chapter of service. And please bear one factor in mind. Thereafter it comes, my lord. Kindly see, my lord, what was the earlier provision which was amended. My lord, there is an asterisk here. An asterisk, my lord, is also quoted. It's not my paraphrasing. Substituted by the Constitution 7th Amendment Act, Section 29 and Schedule 4. Earlier, my lord, it was means a state specified in Part A or Part B of the first schedule. So earlier, prior to the 7th Amendment, the position was in this part, unless the context otherwise requires, the expression state means Part A and Part B states. Delhi was not a Part A or Part B states. I'll come to that later on. My lord, that is one more clinching indication. Then, my lord, 309. Recruitment and conditions of service of persons serving the union or the state. Provided that subject to the provisions of this Constitution, acts of the appropriate legislature may regulate the recruitment and conditions of service of persons appointed to public services and posts. Please note, my lord, in connection with affairs of the union or any state. Those who are working with GNCC Delhi are working for the affairs of the union. Because for this chapter, there is no union territory. Provided that it shall be competent for the President or such person as he may direct in case of services and posts in connection with the affairs of the union, and for the governor of a state. So two things here. Or such person as he may direct in case of services and posts in connection with affairs of the state to make rules regulating the recruitment and conditions of service of the persons appointed to such services and posts until provision, etc. There are two things. By this very amendment, there is an asterisk. The word governor came to be introduced. That is 7th Amendment. 7th Amendment also stipulates administrator for union territory. It does not say governor or administrator. Yes. Second, there is second asterisk. Earlier, prior to 7th Amendment, it used to say Raj Pramukh. Now, Raj Pramukh in 7th Amendment is substituted or amended with the word governor. Kindly bear these two facts in mind. Administrator who comes by this very amendment is not included, and Raj Pramukh becomes governor. There is a significance to that. Para 15. Firstly, not only the recruitment with respect to the person serving in connection with the affairs of the union is exclusively left to the Parliament under entry 7 list 1, but their conditions of service is also left to the. There is an occupied field. Those who are serving in the affairs of the union are appointed by the law made under entry 7 list 1. Now, but it cannot be disputed that the term condition of service includes within it posting, transfer, promotion, departmental action, etc. Secondly, there is one unimpeachable indication that the term union territory is kept outside the purview of 309. It is important to note that Article 309 confers the power to legislate an appropriate law and or make rules governing condition of service of persons appointed for the public services and posts in connection with affairs of the union or any state. This makes it clear that entry 41 list 2 can never be made available to union territory as persons appointed in connection with affairs of the union territory are necessarily appointed in connection with the affairs of the union, and the field is occupied by either legislative enactment or any and or it should be or stroke and I'll change and rules made thereunder, namely under entry 70 list 1, which reads as under the entry under which present regime functions for UT, Union Public Service Commissions, All India Services, and Union Public Service Commission. But all India services, I'll be able to show that from the statutory regime. It is submitted that at this juncture, and elaborated later that there are 3 tiers of services in NCT of Delhi occupied by public servants appointed in connection with the affairs of the Union. All India Service Officers who are governed by All India Services Act 1951, which is undisputably made in exercise of powers under entry 70, list 1. Then DENIC's employees who are appointed and who are governed by DENIC rules, which are made by the President of India in exercise of rule-making power conferred under proviso to Article 309 of the Constitution. And C. Subordinate public servants appointed under DAS rules 2022, which rules are also made in exercise of powers under the proviso to Article 309 of the Constitution, clearly indicating that they are working in the affairs of the Union. Since the field is already occupied by the legislation made under Article 70, List 1, and rules framed under the proviso to Article 309 of the Constitution, and the chapter of services does not contemplate separate services for covering Union territories, the question of examining as to whether entry 41 list 2 would apply to Union territory of Delhi or not may not be necessary unless it is established that Delhi is a state. Delhi is undisputably not a state. But A, NDMC, B is relevant. Constitution's 7th Amendment Act, which introduced the concept of Union territory, made a very significant amendment in the proviso to Article 309 by omitting the word or Raj Pramukh and not introducing the word Union territory. To appreciate this, the following hierarchy of units of governance in India existing at the time of 7th Amendment needs to be understood. There were 4 categories of states, namely Part A, B, C and D, which were having governors for Part A states, Raj Pramukh for Part B states, and chief commissioners for Part C and D states. When 7th Amendment came, there cannot be and there is no dispute that Delhi was a Part C state having a chief commissioner, which became administratable now after 7th Amendment and the Union territory. Now kindly see the proviso to Article 309. Instead of Raj Pramukh, that is Part B state goes, the constitutional amendment says governor, meaning thereby it applies only to Part A states, which are all full-fledged states. The word administrator is conspicuously absent, which was applicable to Part C and D states. They become union territories or some of them merged with other states. The Parliament, while amending the Constitution by 7th Constitutional Amendment, not only not include Union territory while defining the expression state under Article 308 of the Constitution and not include administrator in the proviso to 309, but even omitted the reference to Raj Pramukh in proviso to Article 309 and thereby excluded even Part B states from the purview of Part 14, that is services. This inevitably reflects that Parliament very consciously omitted any separate service for Union territory from Part 14, it should be 4 Part 14, under the heading of services under the Union and the states, but even Part B states under the Raj Pramukhs were also kept out of Part 14. So only Part 1, Part A states, having governors even before them, big full-fledged states. Now, A and B were merged. They became full-fledged states after the 7th Amendment. So that goes. But another indication. Chapter 2 contained in Part 14 relating to services provides for Public Service Commission, which reads as under 315. But same chapter, services, which reads as under. Subject to the provisions of this article, there shall be a Public Service Commission for the Union and a Public Service Commission for each state. Lord, your Lordships can come to sub-article 4. The Public Service Commission for the Union, if requested so to do by the governor of a state, may with the approval of President agree to serve all or any of the needs of that state. But the state can say that UPSC will select, I don't want to have my own service commission. Small states do it for financial reasons, etc. That we don't want to incur infrastructure expenses, etc. Let UPSC decide our role. But kindly see the asterisk, the words or Raj Pramukh omitted by the 7th constitutional amendment. Administrator is not added. Though same amendment introduced the concept of union territory and administrator for it.
Though interestingly, the J&K Reorganization Act incorporates a public service commission for the UTs of Jammu and Kashmir.
I will immediately answer that. Lord. I was to come to it later, but since that has occurred to my Lord, the Chief Justice of India. Well, Lordship, kindly take the Constitution. There is a clear-cut answer. There is a clear-cut answer. Kindly take Article 239 AA. Your Lordship said 3.
239 AA.
AA, sub-article 3. Subject to the provisions of this Constitution, the Legislative Assembly shall have power to make laws for the whole or any part of National Capital Territory with respect to any of the matters enumerated in the state list or in the concurrent list, insofar as any such matter is applicable to Union territories. Now, Lord, for the testing the argument, accept my submission hypothetically that services are not. Services fall within this exception of insofar as, and Manoj, specific exclusions. Kindly see B. If nothing in subclause A shall derogate from the powers of Parliament under this Constitution to make laws with respect to any matter for a union territory or any part thereof. So B says that Parliament can, by making law, give powers even to excluded categories to the union territory. I hope, Lord, I am clear. A restricts the power of union territory. 1, specific exclusions, 3 in number, and 2nd, implied exclusion if it falls within insofar as such matter is applicable. But Parliament can say that no, we may even give police power to one union territory. That is B. I'll again read. Nothing in subclause A shall derogate.
239A is only applicable to Delhi.
Delhi, not the
Delhi only.
I'm saying that. I'm saying something else. Nothing in, tomorrow, kindly see,
What 239, this clause 3B says is that in relation to Delhi also, Parliament can legislate even on the state list.
Exactly, I'm saying, that's what precisely I'm saying. Parliament can say that for NCT of Delhi, there would be a separate state public service commission, or there would be, even police will be under the Delhi administration.
According to you, the Parliament, while enacting the
State Reorganization Act, is a parliamentary law.
They can always delegate, they can constitute an institution such as a public service.
Yes. That is number 1. Number 2, kindly see, my Lord, Article 4.
It's the union which constituted.
Which earlier, kindly see, Jammu and Kashmir again is a sui generis. Example, there was a state public service commission. For good reasons, which are not relevant here, they were bifurcated into 2 union territories. So the Parliament wanted continuance of the Public Service Commission, but leaving it at that. Parliament can, and Parliament did, by law, say that there are no restrictions. You have your own Public Service Commission. That can be done to even Union Territory of Lakshadweep. Parliament can say that you have your own Lakshadweep police service, or your land issue is also given to
Right, but if Parliament is constituting a public service commission for a union territory, which is a power which Parliament exercises, under which entry?
Article 4. Article 4. Article 4, not sub-article 4, Article 4. Kindly see them. Article 4. But first, kindly see 3.
No, the question is
Formation of new.
is that the constitution of the Service Commission in the state of Jammu and Kashmir, if it is in exercise of the parliamentary power, or did the state legislative assembly has exercised that?
Parliamentary power. It is.
How is that, if that is the case, then how is that relatable to Article 4? Not relatable to.
First, kindly see 3.
Yeah.
It is Parliament made state reorganization. First of all, it's not a. After UT of JNK, there is no legislative assembly as of now. So the question of assembly making would not arise. Parliament may by law form a new state by separation of territory from any state, or by uniting 2 or more states or part of states, or by uniting any territory to a part of any state. Increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state, provided that no bill for the purpose shall be introduced in either House of Parliament except on the recommendation of the President, and unless where the proposal contained in the bill affects the area, boundaries or name of any of the states, the bill has been referred by the President to the legislature of that state for expressing its.
But I tell you the problem with this submission. Parliament under entry 70 of list 1 can legislate to constitute a union public service commission. So under entry 70 of list 1, they cannot constitute a public service commission for a union territory. Entry 41 of list 2, according to you, refers to a state public service commission. That will not apply to a union territory.
Which
that means
unless
that
Parliament
means, no. Therefore, even Parliament cannot legislate under entry 40 of list 2 to constitute a union territory public service commission. So there is neither a power in Parliament to do that under entry 70,
I'll answer this
nor is there a power under entry 40 by virtue of your argument, which takes away that power, because that is not a power which is relatable. It doesn't apply to a union territory.
Would your lordship again see para 4, Article 4? And taking their argument at its best.
It's still an answer to it. I'll tell you, there's only one way to answer it, and which is to say that though Parliament does not have an express power either under entry 70 or entry 41 of list, entry 70 of L1 or entry 70 of list 2, Parliament will rely upon, the ragbag, as Justice Venkat Chelaya called it, under entry 97. That's the only way to.
There are two answers.
To break the conundrum. Parliament can rely upon anything which is not specifically conferred is vested in Parliament.
There are two answers. Kindly read along with me once again Article 4. Any law referred to in Article 2 or 3 shall contain such provisions for the amendment of the first schedule and the fourth schedule as may be necessary to give effect to the provisions of the law, and may also contain any such supplemental, incidental and consequential provisions, including provisions as to representation in Parliament and in legislature of or legislatures of the state or states affected. No such law, this is Reorganization Act, shall be deemed to be an amendment of this constitution for the purpose of Article 368.
That
maybe Parliament amended the constitution.
That will not help you, Mrs. Sultan. A first schedule only deals with the territories of the states. What is the territory? Territorial extent. Fourth schedule deals with the Council of States.
Leave the territory.
So when it reads further, supplementary powers, that's in relation to the first schedule and the fourth schedule. That will not. Possibly the only way to save this is to say entry 97.
Kindly see them. And there is another answer as well.
The only way we can say it. Entry 97.
Mr. Mehta,
Yes.
see what is pointed out to you. Union powers are under entry 70, list 1. The state powers are under entry 41, list 2. There is no specific, because entry 41 may not be applicable because it is with respect to state. And even as per the Constitution bench judgment also, correct? Union territory is not, it is not a state. So entry 41 may not be applicable so far the Union territory is concerned. But the question which is posed is under which provision of law with respect to the Union territory, correct? The Union Public Service Commission shall be applicable.
Would your
state public service.
State public.
Would your lawsuits come to Article 246?
Because earlier you say that entry 41 shall not be applicable at all because it is not a state. Because it is under Article 239 AA, it is a special power, hybrid power which is given, which is not equivalent to state at all. Therefore, to apply entry 41, correct, will be erroneous. Then under which provision, correct, it will be applicable. That is what you have said. Article 302, 3 services, A, B, C, correct, different, all these things that we have
on Jammu Kashmir. My lord, I will kindly see Article 246.
And you get the that act, Jammu and Kashmir Act also.
I'll
so that you can have some idea before making any submission on that. Under which provision, under which powers that law is enacted.
I'll definitely apply myself to that and respond.
Because you will immediately get in exercise the powers under so and so, or in exercise the powers. Immediately you can get from that act.
I'll just get it. But put your lawsuit. I'll come to it a little later. I'll apply myself. But please see 246. Oh.
That it's covered by 246(4), that Parliament can legislate on any matter on respect of a territory which is not in a state.
And even enumerated in the state list. Kindly see, my lord, Parliament has power to make laws with respect to any matter for any part of the territory of India, not included in a state, notwithstanding that such matter is a matter enumerated in the state list.
So, is Parliament's legislative powers with respect to union territories?
Yes. So, Parliament can exercise the powers under entry 41 list 2 for this territory, because when the reorganization...
No, that will not help you again, because look at the last part of this 240. Notwithstanding that such matter is a matter enumerated in the state list. So even if a matter is in the state list, Parliament can still exercise power on that area for a union territory.
That's what I'm
This is not even in the state list according to you.
No.
Whether also the fact that 246 falls under chapter 1 of part 11, which is relationship.
Kindly read it again. Kindly, my lord, read it again.
Mr. Mehta, the answer possibly to my question is that this will only be relatable to entry 97 of list 1. Any matter not enumerated in any other list.
Any other matter.
That is, my lord, that can be the answer, my lord. But, my lord, again, my lord.
Yeah. See.
If you have got,
I'll respond.
if you have got
reflect on it.
subsequently you can
reflect on it.
clarify or reflect.
Yes, my lord, but one.
All right, let's go to
one
25.
My lord, even if my learned friend is right, that would mean that provision in the Jammu Kashmir Reorganization Act may be bad in law. That would not mean that the Delhi would have the legislative power to have.
That you have so said in the earlier that they have to show under which provision their services are falling within the
Falling.
yeah. That is what you have already said.
Yes. But
The only point is your argument that there cannot be a public service commission for union territories may be a very dangerous argument. Because you're conceding ground that look, there can't be a public service commission for a union territory.
unless the Parliament permits.
All right.
Well, that's
Para
the
25.
constitutional.
That's the para 25.
And my lord, your lordships, Article 315, which provides for commission, UPSC and the State Public Service Commission, my lord, uses the word governor, not administrator. And this amendment comes simultaneously. It could have said governor or administrator as the case may be. This is constitutional silence. A deliberate silence, when I use the word deliberate silence, because both came under the same amendment, 7th amendment. 315 is also amended. Union territory as a concept is inserted, and administrator is defined for the first time by the very same amendment. The amendment made in Article 3154 simultaneously in 7th amendment again inevitably showed that there cannot be any public service commission for any union territory, including Delhi. Having clarified the position that there cannot be any public service commission for union territories, it needs to be pointed out that the function of the Public Service Commission enumerated in Article 323B also makes it further clear, that union territory can have nothing to do with appointments, promotions and transfers. Please see, functions of the Public Service Commissions. Now it talks of both. The Union Public Service Commission or the State Public Service Commission, as the case may be, shall be consulted on the principles to be followed in making appointments to civil services and posts, and in making promotions and transfers from one service to another, and on the suitability of candidates for such appointments, promotions or transfers. So only union and the state. The position becomes further clear from Article 323, which, as reflected above, omits the term Raj Pramukh and consciously does not include the term administrator, while retaining only governor of the state. Article 323 reads as under. My lord, kindly see sub-article 2. I need not read the whole, my lord. Again, the argument is same. Earlier it was Raj Pramukh. Though union territory came by this very amendment, administrator came by very amendment, it says governor. Raj Pramukh also deleted. And I have given the hierarchy. Part A, governor. B, Raj Pramukh. C and D, joint commissioner. And Delhi, undisputably, till 7th amendment, was part C state having a joint commissioner. Chief commissioner. I stand correct. But now there is another.
I'm not interrupting. I'm just saying, because I need my 90 minutes. The Lordship may have to just overflow. Just because I don't want to interrupt you. I'm just saying something which I don't want to compromise on that.
I'm not repeating anything.
Just something.
Fair. The request is fair.
1 hour is now over.
1 hour is over, but I would request.
I'm not saying
it. I'll not repeat anything. These are.
No, Raj Pramukh, you are repeating.
Let us come to the next.
And administrative Raj Pramukh, you are repeating. You proceed, administrative.
Now, Raj Pramukh will not be uttered by me.
Raj Pramukhs are a relic of the Raj.
Yes.
Gone are those days. Yes.
As your Lordships, my Lord, the Chief Justice of India in one of the matters have said that this is not proposing a girl, that repetition results into any positive result.
I keep on saying that, in the morning when they mention things to you, and constantly, my Lord's 10th. No, my Lord's 10th. My Lord, my client is going to be denied anticipatory bail, 10th. Then you say, no, 12th. No, my Lord's 10th. So, you have to sort of break the ice and say, okay, come on.
That's the very apt analogy, my Lord, that repetition doesn't take yes out of the other person. Another one, now completely, my Lord, forget now chapter 14. But I come to another limb of my submission. Another indication that persons working in the union territory are working in the affairs of the union. No, now administrative tribunal.
I'm sorry, I'm eating into your time, but there's only one aspect, that is 309 gives power to the union government to regulate all terms and conditions of service of officers who are appointed in connection with the affairs of the union. Could it possibly be that, your argument would be that affairs of the union in Article 309 would mean the entirety of the affairs of the union territory, right? Including all services. The other countervailing argument could be that affairs of the union in Article 309 should include those matters which are entrusted to the union by 239 AA. One way of looking at it is, look, the entirety of the canvas of a union territory of Delhi, notwithstanding 239 AA, is an affair of the union, because the union has jurisdiction on list 1, list 2 and list 3.
Therefore.
But that is subject.
Therefore,
it's a little bit.
Your Lordships have in mind.
309 also subject to.
Lord, the Lordships have in mind, Lord, the position, Lord, which is portrayed. Let me demolish, my Lord, fully crafted perception that we have no power. Let me demolish that. Then your Lordships may examine, my Lord, these legal provisions in that context.
Yes.
But para 27. The Administrative Tribunal Act is enacted in exercise of the powers under Article 323A of the Constitution. The said article provides that the Parliament may make law constituting tribunals of disputes and complaints with respect to recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs of the union and another affairs of the state. Now, my lords, may kindly come to section 14 of the Administrative Tribunals. Jurisdiction, powers and authority of Central Administrative Tribunal. The Lordships have, my lord? Page 11. Kindly, my lord, directly come to page 12, the explanation. For those who are acting or functioning in the affairs of the union, there is a Central Administrative Tribunal. For those who are in the state, there is a State Administrative Tribunal. Page 12, explanation. For the removal of doubts, it is hereby declared that reference to union in this subsection shall be construed as including reference also to a union territory. Even their service disputes go before the Central Administrative Tribunal dealing with officers working in the affairs of the union and not, my lord, anywhere else. That's, my lord, the purpose. Now, my lord, establishment of High Court of Delhi. Bottom of page 12.
Yes.
Page 13. There is yet another clear indication that the Constitution treats union territory and UPSC on one hand and the State and State Public Service Commission on the other. Article 241, which is a part of Part 8, that is under the heading Union Territories. It is under this provision that Parliament has made Delhi High Court Act 1966. Article 219, read with Section 4 of the Delhi High Court Act, replaces the word governor with lieutenant governor. Wherever the Parliament wanted, the Parliament has made a provision for governor and lieutenant governor. These similarly, Article 230 and 231 also replaces the word governor with administrator. Pertinently, however, parliamentary law of Delhi High Court side and above quoted constitutional provisions makes it clear that in case of union territories, the Service Commission is only UPSC and none else. Article 241 of the Constitution, Section 4 of the Delhi High Court said, and Article 219 and 230 and 231 of the Constitution are quoted above. 230, your lordships can not skip. So kindly see 232B. This is for Delhi. Having a union territory, and please see B, 2B. The reference in Article 227 to the governor shall, in relation to any rules framed, rules, forms or tables for subordinate courts in that territory be construed as a reference to the president. But again, though it's union territory, the reference in Article 227 of the governor to the governor shall, in relation to any rules, forms or tables for subordinate courts in that territory, be construed as a reference to the president. Then your lordships may kindly see 231, establishment of a common high court for two or more states. This is not for Delhi or any state, but this general provision contained in Part 8. Kindly see the proviso which I have underlined. Provided that if such principal seat is a union territory, there can be a common high court for a state and a union territory. Provided that if such principal seat is in a union territory, The references in Article 219 and 229 to the Governor, Public Service Commission, Legislature, and Consolidated Fund of the State shall be construed respectively as reference to the President, Union Public Service Commission, Parliament, and Consolidated Fund of India. Even if the High Court is a joint High Court for state and union territory, merely because the principal seat is in UT, not Governor, the President, not State Public Service Commission, UPSC, not State Consolidated Fund of the State, Consolidated Fund of the India. Look, there is a thread that there is UT. We don't recognize UT except the powers which are constitutionally ceded, like 239AA.
Yes.
Now, my lord, kindly directly come to page 15. And this is, my lord, the heart of the matter, which would be troubling your lordship's conscience also, because a very well orchestrated perception is that we don't have any power. What do we do? My learned friend argued that we don't have steering wheel, we don't have gears in our hands, we don't have brake, we don't have clutch. Now kindly see, my lord, in that context, and I'll answer, my lord, that question. At the outset, my lord, para 39, and this is, my lord, kindly see, my lord, there are two types of control. My lord, what the central government is claiming is control for recruitment, appointment and posting. Nothing else. Rest governance is with the elected wing. And I'll show that. Kindly see. At the outset, it will be pointed out that there is a clear distinction of legislative powers and consequent administrative powers with regard to Union of India and NCT of Delhi. They are functional control and administrative control. Functional control means right to have steering wheel, right to have gears, right to have brake, right to have clutch under their control. So far as the functional control is concerned, it signifies the control of an elected body in its functioning through the officers and employees working in the affairs of the union. That is, day-to-day functioning under the administrative control and supervision of the minister of the concerned department, the Honorable Chief Minister and the Council of Ministers, that is elected wing. Lord, as my Lord, the Chief Justice of India, Lord, suggested, even in those cases where it is the central end, suppose under 239AA they are entitled, they can function. The officers will be answerable to the Minister, the Honorable Chief Minister and the Council of Ministers, not to anybody else. Please see. So far as the administrative control is concerned, it would signify the decision as to whom to be posted in affairs of the NCT of Delhi, in which position and post such officers or employees would be posted, transfers to be effected and disciplinary action to be taken. This control is absolutely necessary since Delhi is the capital and the central control is not only desirable but constitutionally permitted without in any way interfering with the absolute functional control of the elected wing. In case of NCT of Delhi, as explained hereunder in detail, the functional control vests in the elected wing and all officers, employees are required to function under the administrative control and supervision of the elected wing and implementing the programs and policies of the elected wing which would reflect the wish and will of the electorate, while the administrative control is vested both constitutionally and other in the President and under the order of the President. Kindly allow me to mail, who exercises the same through the Lieutenant Governor. So far as the control is concerned, almost a fiction is created by way of a public perception that they have absolutely no control of the elected government over the officers and employees working in GNCPD. This fictional perception and far from truth, which will become evident from the following paragraphs. Lord, kindly see. In conformity, Lord, your lordships can skip 44. Lord, I'm not taking your lordship's time. Crucial is 45 onwards.
Mr. Mehta, to be on absolute lighter side, nothing to do. When you said that functional powers and the administrative powers and the driving seat, correct, clutch, everything is with them. But according to them, correct, the direction, like GPS, correct, the direction where to go, left side, it is with the central government.
Lord, after reading, Lord,
that is what, this is a distinction between the administrative power and the functional power.
No.
Correct?
I will not respect.
Suppose, according to them, if they want to go straight, they cannot go because of the administrative power, because the direction will be go right side or left side.
Lord, after going through this,
absolutely lighter, nothing.
Yeah, I know. Sometimes it's good, Lord, to have lighter moments. Lord, after going through this, I can say this, Lord, in this very simile, Dr. Singhvi said, they have the steering wheel, they have the gears, they have the clutch, they have the brake, they decide the direction also. Only the make of tires, whether MRF or CH, is done by the LG. And if still you cannot drive, then there is something seriously wrong with your driving ability, not with selection of tires.
But you know, Mr. Mehta, actually, see, as we know in the states, for instance, the most important part is where do you post an officer, right? Whether an officer will be in Secretary Finance, Secretary Home, Secretary Education, Secretary Environment, Secretary Youth Affairs or Sports.
Etc.
So what you are saying is that, look, we will post you as Secretary Finance. Once you are posted as Secretary Finance, you will act under the jurisdiction of the Minister of Finance. We will post you as Secretary Education. Then you will be reportable to. You will report only to the Secretary, to the Minister for Education and the Delhi government. But suppose they find that somebody is not really up to, not functioning as effectively as in that particular role. Your contentions, of course, Dr. Singhvi also conceded that we are not disciplinary jurisdiction. But they cannot even switch officers.
They can. I'll answer your Lordship's question. And my Lord, kindly park that question till your Lordship goes through this. I'm saying this with a sense of responsibility. They can always say that this man is not fit for the health ministry, post it in industries ministry. They have to send a letter through LG to the MHA, and it is never refused.
That's a matter of, that's a matter of accommodation in practice.
Kindly, my Lord,
otherwise look at it from
that question. Kindly park.
An officer knows that, well, I cannot be moved out from this position at all. I cannot be moved out as an excise commissioner, however I do, unless I have a green signal from MHA.
Kindly, my Lord, kindly park.
Really whatever I do as an excise commissioner, what I will do as a Secretary Education.
Unfortunately,
unless I have the green signal, I will never be moved out.
Unfortunately,
will that not dilute even the functional control? That's the point. Yes, recruitment, disciplinary control. You're right, absolutely. Dr. Singhvi, in fact, didn't go as far as that when he made a very nuanced.
I hope, Lord, these are tentative observations.
Question is about posting. You see that?
Lord, sometimes a wrong perception repeated and carefully orchestrated through various mediums, Lord, have the tendency of entering our minds. Lord, the following paragraphs.
All right, quickly, let's read it.
Are devoted to
read it.
Para 45.
And, my Lord, why this is relevant and why your Lordship may park that, my Lord, apprehension, tentative apprehension, till your Lordship, my Lord, goes through.
All right, let's quickly read that para 40.
First, all India service officers and all other officers working for GNCTD are under the functional control of Minister concerned, the Honorable Chief Minister and GNCTD and Council of Ministers as pointed out hereunder. Secondly, for any officer, the most important element of his service is career progression in terms of promotion, which is based upon the annual performance appraisal report. Please don't make any conclusion till I take your Lordship through this fully. Any adverse entry in APA, middle level officers under the supervision and control of the ministers of each department, which includes right from secretary, chief secretary, etc., right from secretary downwards. The Honorable Chief Minister can give suitable grades which will have a direct bearing on his future career progression. APAR consists of annual work plan to be decided twice a year. Now, this answers your Lordship's question. That is, once at the start of the financial year, and secondly, by way of a mid-year review performance. Then, second, the 30% weighted assessment of personal attributes. It consists of following sub-assessment of personal attributes. It consists of following sub-attributes: attitude to work, sense of responsibility, overall bearing and personality, emotional stability, communication skills, moral courage and willingness to take a professional stand, leadership qualities, captaincy to work in time limit. Then, third, 30%. Assessment of functional competency. It consists of following sub-attributes: knowledge of laws, rules, procedures, IT skills, and awareness of local norms in the relevant subordinates or work in a team. All these attributes are decided and gradation is given by the Honorable Chief Minister. Kindly recommend on a scale of 0, that is worst, to 10, best. And also a pen picture on conduct of these officers are recorded in writing by the Honorable CM in these APARs. I, as an officer, cannot say that I owe my allegiance to MHA. I will not take all IAS officers. Principal secretaries, secretaries and heads of the department working in GNCTD and accorded them outstanding rating. Grading from 8 and above is outstanding. Not out of 10. To all officers except one officer wherein very good grading was given to such officer for the year 2019 to 20. Even this officer has been graded as an outstanding officer for the year 2021 and 21-22 by the Honorable CM. Details of Honorable CM. Details of which are mentioned in a, kindly come to page 43. For my satisfaction, please come to page 43. But if I am not working satisfactorily, if I am not fit for that particular post, if I am not listening to the ministers, if I am not discharging my functions properly, if I say that I owe my allegiance somewhere else, then it directly reflects on my APR, which is not to be give one full many credits from his point of view. This was the time where he should have interjected and derailed the argument. I refuse to be derailed.
So, Solicitor, I remember one day when Dr. Singhvi, with his characteristic flourish, came in the morning for mentioning matters before Justice Narasimhan and said, I'm filing an affidavit. Please ask the solicitor.
The Lordship refused.
We refused that. We said, we are not going to go into it.
And repeatedly he's protesting that I will not do it.
All right, but we are not going to be impacted by it. He just sort of said that
that's all right. Individual also is taken individual gradings.
They can refuse that this is a false figure.
But Mr. Solicitor, we got your basic. We'll look at it at a doctrinal level that the APARs are written by the Chief Minister. You may make that limited point. Let's not go into.
Kindly, my lord, come to page.
Anyway, you want to point out
because then
that
you have a whole lot of material rejoined.
Your submission is that apprehension is not well founded. Correct? That though officers are not properly working, correct, nothing can be done. That is what your submission.
Yes, I'm respectful. I'm
because ultimately you say
another
submission is done by the Chief Minister.
No, nothing inconvenient will come. You can sit.
I'm saying nothing. I'm just
you
are the one who's speaking.
Another thing. I am answering your lordship's apprehension that what if the person is not fit for that job? Then, my lord, kindly see page 47. This is not facts. This is a format, standard format. What is the matter in which, my lord, what are the issues on which he is to be judged by the...
in the APRs, right? Annual performance. All right, now let's go on to the next point, Mr.
All right,
we'll now go on to para...
job, etc., not competent.
Now let's read para 59. That's the next point. Yes. I think this point we have covered now.
Yes.
Para 59, Constitution and Statutory Scheme Governing Services. This is what you were showing us last time when we closed on
yes.
Let's look at that now.
But your lordship, say, my lord, kindly, my lord, now to show that
we'll see whether what they have and what
there is something, my lord.
Anyway, already divided into subheadings. Take each of us, we will go through each of them. You tell us broadly the gist of what you are saying and you can make your argument on that in each of those from 59 onwards.
59, your lordship.
59 is the constitutional scheme that you are talking
about. No, Lord, 51, if your lordship. How, Lord, the president has made, my lord, the transaction of business rules. How the officers will work.
All right. That
is a direct bearing.
TBR shows that they work actually under the minister concerned.
And he judges their competence, ability, leadership quality, sincerity, etc., etc. There are several attributes. The council shall be collectively responsible for all the execution orders issued by any department in the name of Lieutenant Governor and contracts made in the name of the President in connection with the administration of the capital, whether such orders or contracts are authorized or not. Then 2, without prejudice to the provisions of Sub-Rule 1, the minister in charge of the department shall be primarily responsible for disposal of business pertaining to that power. You have the power to do. 14. The decision of council relating to each proposal shall be separately recorded and after approval by the chief minister or the minister presiding shall be placed with the record of the proposal. After approval of the chief minister or the minister presiding, the decision of the council as approved shall be forwarded to the by the secretary to the council to the lieutenant governor. Lord, that is for sub-article 4. Differ and refer. 2. Lord, I am giving facts, my Lord, because I have chosen an article that out of 7, I'm sorry, my Lord, kindly, I'm making this with a sense of responsibility.
Yes.
That out of 7 difference, 5 are in this regime. Lord, I am ready to place before your lordships what were the differences.
7 difference.
Lord, I said that from...
Oh, okay. Which I refer to the president.
Lord, that right from, my Lord, 2012 till date, 18,000 files came for differ and refer power. 18,000 files clear, nothing, Lord, it's just, Lord, files. Only 7 times the LG differed. 12 till date. 5 times according to them during this regime. That is true. That's a fact. They could not bring it by way of an affidavit. It came by way of a news item, which I avoided doing. But if your lordship wants to be satisfied that intervention, differing and reference to precedent was a mandate, I am ready to place the files before your lordships. So thereby the file goes to the LG for that power of differ and refer, not for anything. Where a proposal has been approved by the council and approved, record of the decision has been communicated to the LG, the minister concerned shall take necessary action to give effect to the decision. That again minister will take that and direct secretaries and his staff. If the department concerned are not in agreement regarding such a proposal, the minister in charge of any of the department may, if he wishes to proceed with the proposal, direct that the proposal be submitted to chief minister for order or direction or for laying it before the council. Their internal disputes, there can be 2 ministers, there may be difference of views. Then it goes to the honorable chief minister and if necessary to the council. 15. Except as otherwise provided by or under these rules, proposals or matters may be disposed of by or under the authority of the minister in charge, who may, by means of standing orders, give such directions as he thinks fit for the disposal of proposals or matters in his department. Copies of such standing orders shall be forwarded to the LG and the chief minister, provided that such standing orders shall not relate to the statutory powers conferred under any law upon the officials. There are some revisional powers, etc., given to the secretaries under various laws. Obviously, there can't be standing orders that are quasi-judicial powers. Then 16. Minister shall, by means of standing orders, arrange with the secretary of the department what matters or classes of matters are to be brought to his personal notice. Your lordship knows, entire nation, all files do not go to the ministers, whether it's union, state or union territory. But minister can say that these files will have to be given to me for my personal. Otherwise, it is rooted within the administrative, bureaucratic hierarchy. Copies of such standing orders shall be forwarded to the LG and the chief minister. Every Monday, or if it is a holiday on the next working day, the secretary shall submit to the minister in charge a statement showing the particulars of important proposals or matters disposed of in the department by the minister and the secretary and other officers during the preceding week. A copy of the said statement shall be simultaneously submitted to the lieutenant governor and the chief minister. Thus, the functional control for undertaking the governmental business lies absolutely with the minister concerned. Lieutenant governor has no role except constitutionally provided under Article 239AA4. Differ and differ. In case of IAS officers does not, then he is liable for disciplinary action for violation of India service conduct rules. You immediately bring it to the notice of that's the scheme of the constitution and scheme of the rules, service rules, that this man is not behaving properly with me. You take departmental action. Then 53. It is submitted that if any minister concerned finds that an IAS officer or any other officer is violating provisions of TOBR or any conduct rules, he may report it to the disciplinary authority, that is MHA, through Lieutenant Governor, as undisputably the disciplinary authority is MHA. While the appellant is making claims using hypothetical situations that the elected government would not be able to implement its policy without having control over transfer and posting of the officers, the above mentioned TBR, 55 is not a matter where your lordships are deciding about the capital of the nation. So I would be failing in my duty, if I relevant and appropriate for your lordship's assistance.
No, that is why, Mr. Mehta, we are hearing you and listening you.
No, your lordship.
Otherwise, despite your 1 hour has already gone, we are just listening because very important matter is there. Therefore,
I am grateful.
But still you have to consider that.
Repetition, I am speaking. It is most respectfully submitted that apart from the above referred legal position showing services falling within the domain of Lieutenant Governor, the Honorable Supreme Court, with its judgment dated so-and-so and writ petition so-and-so as directed, constitution of a civil service board consisting of Chief Secretary and other high-ranking officers. In case of Delhi, CSP consists on the basis of recommendations made by the CSP. Lord, I have annexed the copy. The following framework ensures check and balances in the system to administer the capital wherein discipline. Referred 3 categories of central services are the categories for the entire country. So far as Delhi is concerned, its administrative setup is as per the following hierarchy. Chief Secretary, then Additional Chief Secretary or Principal Secretaries and Secretaries, then Denic officers and Das officers. This is the broad administrative hierarchy. Now kindly see the provisions. This is again the heart of the matter. How the central government constitutionally and as per statute empowered for recruitment, posting, transfers, etc. Lord, your lordships have seen 239(1). Article 239(1). Lord, I am not reading it. Please read, Lord, Rule 46 of Transaction of Business Rules, framed by the Honorable President. Lord, there are blanks, Lord, para. I will fill it. Lord, it's there already in the Lord paper book. With respect to persons serving in connection with the administration of NCT, the Lieutenant Governor shall exercise such powers and perform such functions as may be entrusted to him under the provisions of the rules and orders regulating the conditions of service of such persons or by any other order of the President in consultation with the Chief Minister, if it is so provided under any order issued by the President under Article 239 of the Constitution. Lord, kindly mark one thing. There is a provision made by the President which empowers the Lieutenant Governor with regard to transfer postings, etc. And if there is any provision which requires him to consult the Honorable Chief Minister, he will consult the Honorable Chief Minister. But bear one fact in mind, action or order of the President in the form of TOBR. Because something would turn when I show the scheme of the GLCPDA. Notwithstanding anything.
Both.
Yes, sir. Your lordships have both the controls. There is no dispute.
Mr. Solicitor, this was not time out for you, huh? So this is included in your time.
The deduction will not be permitted. This is
No deduction
permitted. No, my lord, I am confident of your lordship.
Yes.
Magnanimity and majesty, my lord. Lord, now few pages, but they are very, very relevant.
All right.
And would answer your lordship's query.
Now that next part you can read now.
Yes, sir. Lord, your lordships have seen Rule 46.
Yes.
Empowers the LG to act as per his discretion. Lord, if President provides consultation, with consultation, otherwise without consultation. Lord, now kindly see Rule 57 of these very rules made by the President. At page 24. The Chief Secretary and the Secretary of the Department concerned are severally responsible for the careful observance of these rules, and when either of them considers that there has been any material, instead of giving effect to such departure, he shall personally bring it to the notice of Minister in charge, Chief Minister, and the Lieutenant Governor. There is a mandate that this functional autonomy of the elected wing will have to be complied with. If there is any deviation by anyone, he is personally responsible to bring it to the notice. Now, my lords, may kindly see, my lord, under Article 239AA 7, my lord, please see, my lord, for a second, 239AA 7. There is an act made, my lord, and I am relying upon 2-3 provisions of that act, which I have not argued earlier. 239AA, sub-article 7. The lordship says it. The Parliament may, by law, make provisions for giving effect to or supplementing the provisions contained in the foregoing clauses and for all matters incidental or consequential thereto, and B, any such law as is referred to in subclause A shall not be deemed to be an amendment of this Constitution for the purposes of Article 368, notwithstanding that it contains any provision which amends or has the effect of amending this Constitution.
It's like Article 4, similar to Article 4.
Yes, but even 239AA can be, my lord, buried or changed or modified in exercise of this power. Lord, it's an extraordinary power because it's in union territory. Otherwise, my lord, as I have said, such wide powers are not found anywhere in the Constitution. Now, in exercise of this power, Lord, the GNCTD Act is enacted by the Parliament. And please see Section 41 of the GNCTD Act.
That is at page.
Yes, Lord, when Dr. Singhvi read this, he read only 2 and missed 1. And your lordship would realize why, from his point of view, the right thing. Matters in which Lieutenant Governor to act in his discretion. The Lieutenant Governor shall act in his discretion in a matter, 1, which falls outside the purview of the powers conferred on the Legislative Assembly, but in respect of which powers or functions are entrusted or delegated to him by the President. But I am linking this with Rule 46, a direction of the President which empowers him to act as per his own discretion and not as per the aid and advice of the Council of Ministers. And here...
No, but 46 also says he will exercise such powers and perform such functions as may be entrusted to him under the provisions of the rules. Under the provisions of the rules and orders regulating the conditions of service of such persons. So if the Article 309 rule gives powers to the LG, then he can exercise those powers.
I bow down. The rules are coming further. Now, please see 49. Relation of Lieutenant Governor and his ministers to President. Notwithstanding anything in this Act, the Lieutenant Governor and his Council of Ministers shall be under the general control of and comply with such particular directions, if any, as may from time to time be given by the President. And my lord, my crucial submission for your lordship's consideration is that the notification dated 21st of May 2015 that services will be Lieutenant Governor's discretion is direction of the President in exercise of this power read with Rule 46. The notification dated 21st May is in fact and in substance the delegation of power by the Honorable President in exercise of the powers under Article 239. Lord, Article 239, my Lord, kindly do not forget Article 239, which says the President shall administer Union territory either himself or through administration. So that is first power of delegation. This is, my Lord, that delegation. Read with Section 41 and 49 of the GNCPD Act. My Lord, it was read before your Lordships and it gives an impression as if there is an amendment made. Your Lordships would not go by the language used or your Lordship would examine the substance of the notification, not the form. The form, the direction says that this is the entry which will be governed by the Lieutenant Governor. It has always been governed. And since there was a dispute, the President, my Lord, thought it fit to issue this direction, my Lord, which is traceable under 41 and 49 of the Act. Now, my Lord, kindly see the statutory provisions. Directly answering, my Lord, the Chief Justice's question, service law. What is the service rules? What it provides? It is submitted that all India services under All India Services Act are Central Civil Services Group A at the national level as contemplated under Article 312. It is submitted that the recruitment to Group A services is made by UPSC. My Lord, I may skip that. Your Lordship knows, my Lord, the UPSC conducts exam for various services. Marks are given, IAS, IPS, IFS, IRS, economic services, etc., my Lord. That I can skip, my Lord. Kindly, my Lord, now come to para 70. Para 71, I'm sorry, para 71. The Group A, All India Services, is central services, get their respective cadre under the All India Services Act read with All India Services Cadre Rules 1954. It's already there on record, but the relevant part, which is relevant, I have already quoted. So far as the states are concerned, not the union territories, the officers of All India Services are allotted qua each state. Lord, your Lordship knows their cadre is determined. If I am selected in IAS, I can choose Gujarat as a cadre if my marks so permits, or if my marks do not permit me, I will get any cadre which is left over. So far as union territories are concerned, which are, this may kindly be examined irrespective of the time constraint, because this would be the heart of the matter, my Lord. Again, this matter has more than one heart, my Lord. I repeated it thrice, therefore, my Lord, this is the third heart of the matter, my Lord. My apologies to your Lordship. So far as UTs are concerned, which are directly controlled by the Union of India and not by any state, the officers get the cadre allotted, which is known as Agmut cadre, which consists of the following. Lord, allow me to read because something would turn on this. There is a history behind this, Lord, why this kept on changing. Arunachal Pradesh, Goa, Mizoram, Andaman and Nicobar, Chandigarh, Daman and Diu, Dadra and Nagar Haveli, NCT of Delhi, Lakshadweep, Puducherry, Jammu Kashmir and Ladakh. As on date, these are the Agmut cadre. The Agmut cadre officers can be posted in any of the above referred segments. I can go to Sikkim, I can go to Arunachal, I can go to wherever. All India services are governed by All India Services Act 1951. Then Section 3, 74, para 74. Section 3 of the 1951 Act under the title Regulation and Recruitment of Conditions of Services empowers the central government to make statutory rules regulating recruitment and condition of service of persons appointed to All India Services. The first important rule in All India Services cadre rules, the definition clause are relevant. Now, please see, my Lord, the definition clause of cadre rules. Cadre officer means a member of Indian Administrative Service. So at the top bracket in GNCPD, heads of the department. Cadre post means any of the posts specified under item 1 of each cadre in schedule to the Indian Administrative Service fixation of cadre strength regulations, your lordships are not concerned.
Yes.
Lord, this is crucial. Lord. There are two definitions. One is state. State means a state specified in the first schedule to the Constitution and includes union territory. D. State government concern in relation to a joint cadre means the joint cadre authority. So there are two expressions, state and state government concern. Both separately defined. State means state includes union territory and state government concern means joint cadre, because I will show what the joint cadre is. The constitution of cadres is provided for in Rule 3, which reads as under, there shall be constituted for each state or group of states an Indian administrative service cadre. The cadre so constituted for a state or a group of states is hereinafter referred to as state cadre or, as the case may be, a joint cadre. More than one state. Correct? From the conjoint reading of the aforesaid provision, it becomes clear that there are two concepts, state and state government concerns. Kindly come to the next page, 28. So far as postings of all India officers are concerned, there is a specific provision in statutory rules, namely Rule 7, which reads as under, all appointments to the cadre post shall be made in case of a state cadre by the state government. When there is a full-fledged state, I am allocated or I am allotted a Maharashtra cadre, then by the Maharashtra government. B. In case of a joint cadre by the state government concerned, please note here and park it. Rest may not be relevant for your lordship's consideration. I have quoted so that I am not accused of selectively quoting. 78. The provision based upon which some confusion is created is a provision contained in Rule 11A, which reads as an authority to exercise certain powers in respect of members of the service serving in connection with the affairs of the state, constituting a joint cadre. The powers of the state government under the second proviso to sub-rule 2 of Rule 4 under clause so-and-so, so-and-so, so-and-so and Rule 7. We are concerned with Rule 7, which provides for posting. In relation to members of services serving in connection with the affairs of any constituent states shall be exercised by the government of that state. Correct, Manoj? Now please read further. How, Manoj? This is to be read harmoniously. Your lordships have, Manoj, seen that any definition clause starts with except the context otherwise requires. Unless the context under which I am giving is accepted, 7 and 11A would be in contradiction, distinction to each other, which can never be the intention. Please, it is submitted that a literal and out of context reading of 11A is capable of creating a confusion that Rule 11A and Rule 7 contained in very same rules are in contradiction to each other. At the outset, it is submitted that the word joint cadre in Rule 11A is in right context used as a joint cadre of two full-fledged states without any union territory. And I'll read it 11A again. In Rule 11A, the word state is not used as defined under Rule 2C, which itself starts with unless the context otherwise requires. Rule 11A applies when there is a joint cadre of more than one full-fledged states. In such a case, the power under Rule 7 would be exercised by the government of each constituent state. But Assam and Meghalaya has a joint cadre. Then Assam will decide Assam officers, Meghalaya will decide Meghalaya officers. And there is a history behind it. But please note, 11A was inserted subsequently after 1972. And that will make it clear that 11A is not in contradiction to 7. It says when two or more full-fledged states create a joint cadre, then 11A will apply. But kindly allow me to show that history. The provisions of Section 11A was introduced on 11 January 72, as a separate state of Meghalaya was to be formed, on 21st January 72, separated it from Assam, just 10 days before the separation. Otherwise, my lord, this cadre was entirely UT cadre. Both divided state of Assam and carved out state of Meghalaya. No, I'm sorry, I stand corrected. Not all were not UT cadres, but my lord, this bifurcation happened. Had joint cadre then and continues to have a joint cadre even now. In other words, Rule 11A is not in conflict with Rule 7, and in both the rules, the term state would mean full-fledged states. When there is a joint cadre with some union territories also included in the joint cadre, the posting would be made by the state government concerned. Lord 7B, your lordship would recall. As stipulated in 7B, as noticed earlier, the power of posting is vested in state government concerned under Rule 7 of the Indian Administrative Service Cadre Rules. The term state government concern is defined in Rule 2D of the said rules, which means joint cadre authority. Now, kindly pause here for a minute and minutely see, 11A doesn't use the word state government concern. It says by the state, respective state. Therefore, the intention is, in view of the historical background, that when there are two or more full-fledged states having a joint cadre, then the state government concerned will decide. Their state would not include union territory. As noticed earlier, I'm sorry, not 85. For this purpose, now, who is, your lordships have seen, state government concern means joint cadre authority. Now, who is the joint cadre authority? For this purpose, it is necessary to go to All India Services Joint Cadre Rules, which are statutory rules. Rule 1-2 reads as under, they shall apply to joint cadre constituted for any group of states other than joint cadre of union territories. Kindly mark this. Something may turn. Then definitions. In these rules, unless the context otherwise requires, joint cadre authority means the committee of representatives referred to in Rule 4. And constituent states would mean states in respect of which a joint cadre is formed. That is the states. These are the rules not made in 72 itself. The lordships would notice this. At this juncture, a little history as to why All India Service Joint Cadre rules were required to be formulated and why they were formulated may be relevant. The joint cadre rules were framed when there was one service for all union territories, that is pre-Agbot era. All union territories were clubbed together before 72. This is the reason why Rule 1-2 excludes joint cadre of union territories. When the joint cadre of only one union territory was in existence, the joint cadre authority was Ministry of Home Affairs for all union territories under the Government of India Allocation of Business Rules 1961, which are made in exercise of powers under Article 77 of the Constitution of India. The relevant part reads as under, my lord. Kindly read, my lord, the highlight, the underlying portion. This is for union territories, then union territory with legislature. There is a detail, my lord, without legislature, with legislature. We are concerned with legislature, and that too NCT. There is a separate provision. These are constitutional rules. I will not read, but I will cite a judgment that rules made by the president have the statutory force. It's having the force of a statute, not just statutory rules. All matters falling within the purview of the union government in terms of provisions contained in Part 8 of the Constitution, insofar as these are applicable to National Capital Territory of Delhi and the Government National Capital of Delhi Act, excepting matters with respect to entry 18 of the state list, and all such matters as have been specifically assigned under these rules to any other ministry or department of the Government of India. Kindly come to D, page 31. General questions relating to public services in the union territories and service matters insofar as these fall within the purview of the state government relating to officers of Indian Administrative Service and Indian Police Service, serving in connection with affairs of the Union Territories. All service matters. Under the rules framed by the President under Article 73. Then NCT of Delhi, Andaman and Nicobar Islands, Lakshadweep, Daman and Diu, Dadra and Nagar Haveli services, that is DENIS, and Puducherry Civil and Police Services, etc. This is how these rules have been understood and applied by the Government of India. Right from inception, this is how these rules are applied. The Joint Cadre Authority for All India Service Officers in cadres having union territories is MHA. Now kindly see further. Till the year 1987, the following union territories were having a joint cadre. Lord, kindly read this. Arunachal was a joint cadre, was a UT. Goa was a UT. Mizoram was UT. And rest, even today are UT. Correct? I'm not reading. Out of the aforesaid union territories comprising of union territory cadre, that is post-Agmut era, the following 3 union territories became full-fledged states in the year 1987 itself. That is Arunachal Pradesh, Goa and Mizoram. As a consequence of 3 out of the 10 union territories having joint cadre becoming states, the central government was required to take a decision about the treatment to be given to this newly emerged joint cadre, as a result of which a separate cadre was reconstituted, which came to be known as Agmut cadre, which consisted of 3 newly become states carved out of the union territories with remaining union territories. So 3 states, it was a hybrid kind of a cadre, 3 states and 7 units, which continues till date with addition of Jammu, Kashmir and Ladakh now. The Joint Cadre Authority, however, continued to be the Ministry of Home Affairs, Government of India. Under the rules made by the President, which I read, it is submitted that prior to the creation of Agmut cadre, all functions of the cadre controlling authority, that is state government concerned, under Rule 2D, referred above, was being exercised by the Joint Cadre Authority, which was constituted with a notification dated 3/4/89, a copy of which is annexed herewith and marked as Annexure D. Lord, if your Lordships can, allow me to read that. That's already a part of the record, but it is, this is the quotation. Yes. 71. Page 17. I'm sorry. This is a part of my earlier document, but I'm just for ready reference so that your Lordship gets it in one document. In exercise of, your Lordship gets 71. In exercise of the powers conferred by subsection 1 of section 3 of the All India Services Act, read with sub-rule 1 of Rule 4 of the All India Services Joint Cadre Rules, the central government, in consultation with government of states concerned, hereby constitute the Joint Cadre Authority for joint IAS, IPS, IFS cadre of Arunachal Pradesh, please mark, Goa, Mizoram, and Union Territories as below. This is pre-Agmut. Chief Secretary Arunachal Pradesh, Chief Secretary Goa, Chief Secretary Mizoram, Additional Secretary in the Ministry of Home Affairs in charge of UTS Division, and Joint Secretary UT in the Ministry of Home Affairs. Yes. This was, my lord, pre-Agmut position. Now kindly, my lord, come back to page 32. Are your lordships with me at page 32? Yes. Para 92. After the aforesaid change, the Joint Cadre Authority held its meeting in October 1988. The resolution passed and decision taken at page 137-139 of Convenience Compilation Volume 4. However, for ready reference, the relevant parties reproduce here. The resolution passed is on page so change. Lord, kindly see these minutes. And Lord, this will connect the dots how the Union of India became the Joint Cadre Authority for postings, transfers, etc. etc. Now, that 4-member committee deliberated and passed this resolution. This was a joint cadre authority then. Prior to reorganization of the UT cadre as a new joint cadre of the IAS IPS known as Agmut cadre, all functions of the cadre authority as well as of state, as defined in various rules, regulations governing the terms and conditions of all India services, were being looked after by the Ministry of Home Affairs. However, the attainment of statehood, after attainment of statehood by some of the union territories, and consequently after reorganization of the cadre, the government has notified the constitution of joint cadre authority for the joint cadre with a notification dated so and so, which I read, thus bringing the joint cadre within the ambit of All India Services Joint Cadre Rules as amended from time to time in addition to other service rules. In the interest of proper management and smooth functioning of the joint cadre within the four constituent units of the cadre, namely Arunachal, Goa, Mizoram and Union Territories, it has become imperative that the joint cadre delegated some of its routine functions to and authorize the Ministry of Home Affairs within the UT division and other constituent units to exercise those functions and powers, though within the policy framework as determined by the joint cadre authority from time to time. JCA has given a serious thought to the above proposal. JCA has pointed out above, in the interest of cadre management, strongly feels that service matters of local nature, which do not have any adverse impact on the overall structure of the services or the cadre as such, should be dealt with by the constituent units at their own level, as it may not be practicable or desirable for the joint cadre authority to go into these matters in detail. Now, Manoj, the delegation comes. Functions to remain with MH, UT division. Transfer postings of cadre officers from one segment to another. However, for this purpose, JCA will frame proper guidelines, keeping the overall interest of the service officers as well as the constituent units in view. Till the new guidelines are framed by the JCA, transfer postings from so-and-so will be guided by the guidelines as existing on the day. Then, Manoj, kindly skip and come to page 93. Para 93, I'm sorry. It is submitted that this is how the Ministry of Home Affairs continues to remain the joint cadre authority. These rules are not under challenge. Cadre rules are not under challenge. Joint cadre rules are not under challenge. No act is under challenge. In the context of the above referred statutory scheme, it is necessarily for the GLCTD to show to this court as to how it is the cadre controlling authority or joint cadre authority which can exercise any powers over All India service officers under Rule 7B of All India cadre rules. But I am showing something which they have not been able to show while asserting a particular constitutional proposition. At this juncture, it is relevant to note that President of India had already delegated. Now, your Lordship would have the question, why, how LG comes? Well, this is the answer. At this juncture, it is relevant to note that the President of India had already delegated all powers relating to services of Union territories to the administrator, that is Lieutenant Governor, with a notification dated 59, which is superseded by the notification dated 24th September 1998, which is a part of the record I have just quoted for ready reference. In pursuance to the powers conferred under Clause 1 of Article 239 of the Constitution, the President hereby directs my apologies. The President hereby directs that subject to his control and until further orders, the Lieutenant Governor of National Capital Territory of Delhi shall, in respect of the matters connected with public order, police and services, exercise the power and discharge the functions of the central government to the extent delegated from time to time to him by the President in consultation with the Chief Minister of the National Capital Territory of Delhi, except those cases where, for reasons to be recorded in writing, he does not consider it expedient to do so. This is how the LG comes into the picture. This came to be substituted by the impugned notification. There was already this notification in the year 1990. This is now further clarified in the impugned notification. Now, I am clearing the ground for all India services. IAS, they head the department. Now, kindly see Denic services, the second tier of administrative setup. There are 33 services which are part of Group B Central Services. Amongst these 33 group services mentioned at serial number 28 and 29 provide for services for combined union territories, namely Delhi, Andaman Nicobar, Lakshadweep, Daman and Diu, Dadra and Nagar Haveli, they called Denics. Officers are, police are Denics, but we are not concerned, police is not with them. That subject is not with them. It is submitted that Denic service is a feeder cadre for all India services, namely Indian Administrative Service. In other words, the Denic officers can be promoted to Indian Administrative Services, promoted to. There are many Denic officers who work as special secretaries in Delhi, other union territories which are governed by Denic rules. All of them are union government officers working for the affairs of the union. Well, then I have said they are selected by UPSC in page 98, which I'll skip. Then, Manoj, kindly come to 100. It is submitted that National Capital Territory of Delhi, so and so Denic Service Rules 2003 are made by the President of India. Lord, my Lord, the Chief Justice's question in 41. Then which are those rules? Chief Justice of India. President of India, in exercise of powers conferred by the proviso to Article 309 of the Constitution, the relevant provisions are mentioned in definition clause so and so. Administration means the government of National Capital Territory of Delhi in respect of national so and so. Administrator means the administrator appointed under Article 239 of the Constitution for union territories of so and so as the case may be. But here, administrator, we read LG. Appointing authority, please note this and highlight this. Can't be highlighted in digital version. Otherwise, we.
No, it can be highlighted.
It can be.
Can be.
I'm sorry. I'm sorry.
It's been highlighted.
Lord, I am at a KG level of Lord, this because of your lordships, Lord. Not because of your lordships, due to your lordships.
No, it is good that you have got the admission.
Yes. I got that.
KG or no KG?
And
My judicial clerk told me just 2 days back that you use the preview option. If you use the preview option, then you'll be able to highlight. If you're using in the Adobe version, sometimes there's a problem in highlighting in some of these PDF files.
No, we use Liquitext.
Oh.
I don't know. Maybe Adobe is and Liquitext is same. But I do not know.
Oh, you're not working on a Mac. But just see, you'll be able to, even on liquid text. I haven't used liquid text, but I'm sure you have a highlight option.
Both have the option.
Yes, there is.
There they are.
There is.
Yes, okay.
Right on the top of the.
The color, you can color also. But the pleasure which Dr. Singhvi and me are getting with that broad nib pens we are missing. I think there would not be any.
There is a broad nib pen even in the preview options.
Your lordships are right. That I know. There are several options. We have only one nib. Here there are several. Your lordships are right. I stand corrected. Then, kindly see appointing authority. In relation to any grade means the authority empowered under the central services, classification, control and appeal rules to make appointment to that grade. Then, cadre, services, then composition of services. Then kindly come to Rule 12. At the foot. The same rule, Denic Rules 2003. Every members of the service allocated to an administration means NCT Delhi, you have read the definition, unless he is appointed to an ex-cadre post or is otherwise not available for holding a duty post owing to exigencies of the public service, be posted against a duty post under the administration by the administrator concerned. The administrator is NG. By definition, Article 239 defines, and this rules also define. Then allocation of members of the service. The government shall, from time to time, allocate a members of the service to any administration for posting in terms of Rule 12. The government obviously means central government. because it's a joint cadre of several UTs, will post officers of Danik for being posted by the LG. These rules are also not under challenge. It is submitted that Danik rules further state that vacancies in Danik shall be filled on the basis of civil service examination conducted by the UPS. Your Lordships can skip and come to DAS. So DAS is the third tier and not the last tier. Lord, may I take 15 minutes after lunch? Only 15 by the clock.
You can continue.
I have to.
3 paragraphs are there.
Now, 3 paras you want to complete right now?
Please, Manoj, I will barely finish at 4 o'clock. Your Lordship has got mentioning. I will barely finish at 4 o'clock.
May I have your Lordship's leave to mention, my Lord? Would your Lordship be allowing us oral submission?
Your Lordships had rejected this prayer on Thursday. If your Lordship has applications on either side, we can have so many applications, Balas.
Assistance is to be given to the Constitution Bench.
Mentioning at 2 o'clock, so we'll take up mentioning. Do you want to take mentioning at the end? So, mentioning end mein rakhiye.
My Lord, I just want to know, would your Lordship be hearing me orally or would you want?
We'll circulate a notice that we'll commence at 2 o'clock and we'll take up mentioning after CB is over.
Kindly.
So we'll take.
My Lord, would your Lordship be hearing me, my Lord? I just want to know.
Lord, I'll just make a request. I'll tell you. Lordship,
I will also have associations then. What's the point of it? This is really
there is no association. There is no other association.
Mr. Sarve, now everything has been covered by.
On Kumar Jain, that Mr. Salve, he said, I will deal with it. He said, all right, I will not.
That's not fair. With great respect. This
is a matter where life coming from
I have never heard of
all right, we'll see. We'll see that.
Coming with this kind of time constraint.